Now let's study Doctrine of Privity to Contract. Privity means privacy or something that is private or personal to the contract. Here this is in reference to the parties to contract. Now, essentials of privity to contract application or claim, like when this privity, doctrine of privity will be invoked. Contract entered between two parties. These are the essentials. If these essentials are there, then only it can be invoked. So the first is contract entered into between two parties, two or more parties at least. So there have to be multiple parties. Now the second one is that parties must be competent to contract, and there should be a valid consideration as well in the contract or in the agreement in order to become a contract, and because then only it will be enforceable by law. So competence of the parties and existence of consideration are the prerequisites for application of this doctrine, because if these elements are there, then only this doctrine will be applicable. The third element is there has been a breach of contract by at least one party, because if there is no breach, there is no applicability of this doctrine, because we apply this doctrine only when there is some problem. Otherwise, everything is going on smoothly. So this will be applicable when there is a breach by at least one party. So it says that breach of contract by one party is essential requirement for the application of the doctrine of privity. Now, and the fourth element that is required for this doctrine to be invoked is only parties to contract can sue each other. Like if some party is not private to the contract, or if someone has not entered into a contract, or there is a third party, they cannot sue the parties to contract. So this is what doctrine of privity says. Of course, then there were some legal developments, courts issued rulings. So there are some exceptions as well that we will study later on, but this is the basic idea of privity to contract, that contract is private to the participants in the contract or the parties to contract. So a contract is private to the parties to contract. Later on we will study like that the benefits can be given to extraneous parties or outside parties as well who are beneficiaries. So that we will study later on, but the basic idea is this, that only the parties to contract can sue each other. And the privity of contract means that it is private only to the participants or the parties to contract, and this doctrine says that only parties to contract are entitled to sue each other. Now, Doctrine of Privity under Indian Contract Act 1872. Now, Section 73 of the Indian Contract Act provides for compensation to the party by the party breaching the contract. The party who breaches the contract is liable to pay compensation to the party against who they have breached, or the suffering party. The suffering party will get and the offending party will pay. In Section 73, it appears that compensation arises for actual damages caused due to non-performance of the contract and not indirect damages. So, under this consideration, it seems that only pecuniary damages are taken into account. This means monetary damages, that those can be measured in the terms of money. So, only those damages are taken into account. So, if somebody asks, like two people or two parties enter into a contract, and one party offends and other parties loses something, and we can measure that loss in the terms of money. So, the offending party will pay compensation to the suffering party. In estimating the loss arising from the breach of contract, the means of remedying the inconvenience caused by the non-performance of contract must be considered. This means like if a loss has been caused to one party, say there are two parties A and B, and B breaches the contract and A suffers. Now A suffers and damages have been caused to A, but it is also seen like what remedies did A have and whether A resorted to those remedies or not. It is not that if B offended, then A should allow damages to be caused and only wait for compensation to be paid by B. So remedying the inconvenience caused by non-performance of the contract are also taken into account, that what were the remedies available those A could have used and avoided those losses. Now section 73 states, in estimating the loss arising of breach of contract, inconvenience caused by non-performance of contract must be considered. Like the inconvenience caused due to non-performance of the contract or whatever was promised, if a party does not fulfill that promise, the inconvenience caused to the other party must also be taken into account while estimating the losses. Now, exceptions to the privity of contract. There are certain exceptions to the privity of contract as well, and those are studied under benefit aspect of contract. Then there is burden aspect of contract. Then doctrine of privity under law of agency, like where there is an agency or a principal and agent relationship. So how doctrine of privity is applicable under those circumstances. Now benefit aspect of contract. Now let's study benefit aspect of contract. A person stranger to contract cannot enforce the contract except some exceptions defined in court rulings or previous cases. Like court rulings are issued by the constitutional courts and all people follow them. So under those rulings there have been certain exceptions. So those rulings provide some exceptions. So those need to be followed as well. Now, two basic courts have ruled exceptions where the stranger to contract can sue other party or the other parties, like beneficiary or beneficiaries under the contract towards who contract creates trust, and beneficiary or beneficiaries under the contract which is part of family arrangement. Like if there is a family arrangement and two people have entered into a contract and there is a beneficiary who is also a family member, so he is not party to contract, but if some consideration has been paid by one of the parties to contract in favor of the other member, so under those circumstances the court has issued rulings that doctrine of privity will not apply because that person is also a beneficiary and it is a part of family arrangement. So this was about arrangement. And then burden aspect of contract. Burden of contract stands for liability or obligation created by the contract. Now burden aspect of contract means like when two people agree or promise something, then there is some liability created towards the other party by each of the parties, and that those are mandatory on them. And a contract gives right to a party and assigns duty to other parties. Like if there is a contract, there has to be a consideration, means a person has a liability, they will pay consideration, and then there are duties to fulfill the consideration for the other party as well. So there are a contract creates a right for one party and liability for other parties, but this is for both the parties, as both are liable to pay consideration to the other party. Now under doctrine of privity, if we study agency, so under this head we will study application of doctrine of privity under the case of agency, where there is an agent and principal relationship. The principal-agent relationship is named as agency. Also, the agent does the agency work by representing the principal towards other parties. He represents his principal towards other parties. The principal as well as the agent in their own capacity have certain rights and duties towards other parties directly attributable to the acts of the agent or the agency. Like agent as well as the principal have some duties towards other parties, and in this case any act of the agent where he is representing his principal is also directly responsible towards other parties through his agent as well and directly as well, because agent is representing the principal. So there are certain circumstances. Of course, there are also exceptions where principal will claim that he is not responsible. There have been court rulings, but there are so many court rulings and they always come up. But as a general idea, according to the doctrine, the principal is also liable for the acts of his agent, because he has already created an agency, and creation of an agency itself is a contract. So when he is a principal and he is imposing some duties on his agent, so he is also responsible. So this is how things move on, and responsibilities are imposed on those people who were earlier keeping themselves away. And when transactions takes place in the world, and cases come to the court and new rulings are issued, and when such developments takes place, then those people who were hiding also come to the fore. So this is how it works, and it has worked. Now we can find earlier principals used to prevent themselves against the acts of their agents, but now as the time is moving on, principals are becoming more responsible than earlier. In most cases specific to agency, despite the agent's fault, it is treated as that the principal has committed that fault, or the principal is liable towards other parties for the acts or omission of some acts by his agent or the agency. Agency may be an organization as well. He has created an agency. So some people are working for that agency. So employees are working for the agency. So if employees have done something, means agency has done something. And agency is for the principal. Principal has appointed the agency. So principal is responsible towards other parties in case of any fault of their agent or the agency. So, and there are certain exceptions to the rule of privity to contract, and recognized by both English law as well as Indian law. Some are not recognized by Indian law, and almost everything is recognized by Indian law. Of course, there are some exceptions as well, like the consideration should not move from like to the promisee. The consideration should not move from the other party, or the promisee himself should pay the consideration. This is in English law but not in Indian law, because there was a ruling from South India. So this is one of the examples that we will study later on, but for now we can say that there are many things those are similar, because Indian law is based on English law, but sometimes there are exceptions as well. So this was regarding exceptions to the rule of privity. And then now we will study the exceptions in detail in the next video.